Julie, what we uncovered is hundreds of admitted child molesters, rapists, and child porn possessors who were not on the state's sex offender registry or even the public online courts database. And despite them admitting to serious crimes against children, Minnesota judges and prosecutors are granting them special secret status, sometimes with tragic consequences.
Across the street from this Maplewood Park, behind the front yard cross, lived a man with a dangerous secret.
Wolf in sheep's clothing.
A secret masked by the state of Minnesota.
He turned out to be a child molester.
47-year-old Eugene Robert Finch was a landlord and owner of a handyman company.
Called himself the Handy Dandy Man.
The Handy Dandy Man was just sentenced last month in Ramsey County to 4 years behind bars for sexually abusing an 11-year-old girl whose family were his tenants. That's Mom on the right, Grandma on the left.
He molested my granddaughter. He put his hands in her pants. He got her to touch him in places she never should have.
To protect the child, we're not identifying her family. They tell us Finch kept belongings in the garage connected to the home they rented and was over all the time, helping with yard work and even babysitting.
We thought he was the greatest landlord on the face of the earth.
But in his garage, he used the promise of toys,
Barbie dolls,
kept in a box,
Barbie dolls,
to get what he wanted
brand new Barbie dolls.
From the girl.
I feel like I should have known. I feel like this whole thing could have been prevented.
Could a little girl having her innocence ripped away have been prevented? Our investigation discovered Eugene Finch has done something like this before, but his past was kept largely secret by Minnesota's legal system.
Digging into Finch's secret past takes us north to Carleton County, Minnesota. Here, we discovered a prior child sex case from 2014. Court records show Finch was driving his Hummer SUV up from the Twin Cities and repeatedly having sex with a 13-year-old girl. Finch was arrested, facing 3 years in prison and placement on Minnesota's sex offender registry. But instead, he received a plea deal that shielded his crime from the public.
He got in kind of a sweetheart deal up there.
Finch received what's called a stay of adjudication. That means he admitted he's guilty, but instead of prison, he got probation. But that's not all. The stay meant that if he successfully completed probation, a judge agreed his case would be dismissed with no conviction on his record.
They basically slapped his hand and let him go off.
To further shield Finch while on probation, no information about that charge could be found on the state's public online criminal court database. Unless someone physically went to the courthouse to search, the public had no real way of knowing the man living across the street from a playground and babysitting children was a threat.
We didn't know.
I had no idea.
Did you have a right to know?
Anyone had a right to know. It should have been on the registry. It should have been made public.
While still on probation for the Carleton County child sex case, Finch was arrested in North St. Paul for the Barbie doll incident with the 11-year-old. Court records show investigators found a trail of other alleged victims, including a child, reportedly offered money by Finch to let him touch her private girl area. In exchange for a guilty plea in the Barbie doll case, he was not charged with any additional crimes. At Finch's sentencing, Assistant Ramsey County Attorney Corey Tennyson called him a predator and his previous stay of adjudication in Carleton an insane benefit, resulting in a devastating effect on the victim and her family.
I feel like it's just been so hard.
These people pose a public safety threat.
Camille Cooper is with the National Association to Protect Children, which recently released a blistering report about sex crime sentencing in Minnesota. It called allowing predators to disappear through stays of adjudication a dangerous practice that should be looked at closely by the legislature.
Is that something that has been looked at closely by the legislature, to your knowledge?
It's going to be looked at closer.
While promising to look closer, Representative Tony Cornish, who heads the House Public Safety Committee at the state legislature, told us lawmakers never intended for stays of adjudication to be used for serious offenses like child molestation.
Well, a stay of adjudication was supposed to be used for less serious offenses. Somebody didn't have to worry about so much in the future.
Carol Evan wanted to know how many more of these insane benefits, stays of adjudication shielding sex offenders from public scrutiny, have been given out in Minnesota courtrooms.
Welcome to the Minnesota Sentencing Guidelines Commission.
The Sentencing Guidelines Commission couldn't tell us. They don't track it. And the state court system refused to even release the names or case numbers of people receiving stays of adjudication, citing the privacy of people like Eugene Finch, who originally admitted his guilt in Carlton County, but technically had not been convicted of a crime.
It's really a bad situation when you mask any type of offense like this.
Eventually, the state did release partial records, showing only the age of the defendant, the sex crime they were accused of, and the county where they received their stay of adjudication. We just analyzed cases for adults 22 and older. Between 2006 and 2016, we found 210 defendants, ages 22 to 85, who received stays of adjudication for their sex crimes against children, including cases involving sexual penetration of children under 13.
How's that possible that you can have sex with a minor and not have any record of it anywhere?
Which county a defendant commits their crime in is a major factor. In Ramsey, Washington, Dakota, and Carver counties, no stay of adjudication plea deals have been given. In Hennepin, just one. Anoka and Scott counties both have 4. Wright County has the most. The court here allowed 35 stays of adjudication. We wanted to know why. We asked for an interview. Wright County Attorney Tom Kelly's office sent us this letter that says in part, criminal sexual conduct cases are often very difficult to prove. They make the argument that in some cases, the probation restrictions that come with a stay of adjudication are better than going to trial and risking an acquittal. A valuable tool for prosecutors or an insane benefit shielding child predators? A question Minnesota lawmakers will now wrestle with.
Want to take a look at this and bring it in for at least a hearing and seeing what's going on.
What's going on?
It's turned my family upside down.
In this case, it's a family living with the fallout of a sex offender kept secret.
When things like this are just wiped under the rug, it's terrible.
A big question we have, and I imagine you have now, is, hey, give us some context. How many of these secret sex offenders like Eugene Finch, who get this big break by the court, go on to reoffend, victimizing additional children? The courts tell us they don't know, and there's no way to track it. Julie.
A KARE 11 investigation is prompting new efforts to protect children from sexual predators. Lawmakers are considering reforming Minnesota's sex crime sentencing laws after our investigation found loopholes that kept some offenders off state registries. Investigative reporter AJ Legault has the story.
It is a severe present crisis.
April Kane is one of the victims of child sexual abuse to speak out today, calling for tougher sentences for those who rape and sexually exploit children.
The minimum sentencing guideline in Minnesota are a disaster.
Judy Rangel is another.
And the laws in Minnesota are horrific.
Lawmakers are wrestling with how to best go about calls for sentencing reform.
Right now, our best isn't good enough.
Representative Matt Grossel is the chief author of a proposed bill that calls for numerous changes to how Minnesota sentences those who prey on children.
I'd like to play a short video.
Those videos played at the Capitol today, masked by Minnesota's legal system. KARE 11 investigations into legal loopholes that have shielded from the public the crimes of some of those who sexually exploit and rape children. He got what's called a stay of adjudication.
We've got to take a hard look at this statute.
Grossel's proposal calls for completely doing away with stays of adjudication and other plea deals that reduce felonies to misdemeanors. It is a controversial measure that some, including county attorneys and even advocates for sex assault victims, feel may go too far.
A stay of adjudication is one of the tools that prosecutors use.
There seemed to be consensus that the crime should not be kept largely secret as they currently are.
Those stays need to be searchable online in our court systems.
Beyond that, a lot of debate, but little argument that some change is called for.
I believe that there are things that we should change. I believe that we have a lot of work to do between now and the time that we pass a bill.
The new law proposal also increases penalties for child pornography, something our investigation found only lands you in jail about 10% of the time. Now, the bill passed through the Public Safety Committee today for possible inclusion in a larger omnibus bill. We'll, of course, keep you posted on just what happens. A bill to toughen punishments for sex crimes and increase transparency in the sentencing of admitted child molesters met its legislative death, at least for now, as Minnesota's Senate decided taking no action was safer than what they called hasty action.
Secret crimes, betrayed trust.
He turned out to be a child molester.
The state of Minnesota knew what this mother and grandmother did not, that their landlord and babysitter, Eugene Finch, was a child molester.
Did you have a right to know?
Anyone had a right to know. It should have been on the registry. It should have been made public.
A KARE 11 investigation exposed how Finch and hundreds of other predators received plea deals known as stays of adjudication. That means they admitted guilt, but instead of prison, got probation. And if probation is successfully completed, the crimes disappear from their record. The result is secret sex offenders. No registration, no record on the court system's online database. No real way for the public to know they're a danger until, like Finch, they strike again.
It's just been so hard, and this whole thing could have been prevented.
There was outcry for Minnesota's most powerful.
I think it's wrong. I think anybody who commits a sex crime needs to be on the public register.
KARE 11 also exposed how 88% of those convicted of child pornography crimes get probation, not prison. That led the national organization Protect to write that Minnesota's sentencing for child exploitation material is, without a close second, the weakest in the nation.
Probably the weakest state we've ever seen nationally on child sexual abuse. It's time for the hatchet and not the scalpel.
Representative Matt Grossell introduced sweeping sex crime sentencing reform legislation that would have done away with stays of adjudication and stiffened penalties for child pornography. It also called for increased transparency, something even those critical of the overall bill said made sense.
It should be public, and that's an easy fix to do.
But in politics, easy apparently does not mean quickly. The measure came to a screeching halt when the Senate refused to take it up this session.
It's not a question of not taking action. We want to do the job right. We need more time.
Senator Warren Limmer points to the bill's many critics, including the County Attorneys Association, who think the reform measures go too far. Limmer claims the bill needs tweaking, and it won't happen this session.
This issue is not going away, and you have my word that it's going to be addressed.
They're telling me next year. And, you know, I'm thinking to myself, well, next year we're going to have more victims by then.
California outlawed the use of stays of adjudication in child sex cases back in 2005. Will Minnesota do the same? Senator Limmer says he expects to hold hearings this summer so that the issue can be addressed next session.
Investigative reporter AJ Legault is here with more on what he's found. AJ?
Julie, from babysitters to bus drivers, our investigation discovered sexual predators with dangerous secrets, kept hidden by a legal system seemingly more concerned with preserving the privacy of pedophiles than protecting the public.
Behind the wheel of a school bus is not the place you expect to find a self-confessed child molester.
You're trusting the school, the bus company, who's ever hiring them.
But that's exactly where Glenn David Johnson was working earlier this year, transporting kids to and from Blaine High, Roosevelt Middle, and Jefferson Elementary, when he was charged for a second time with molesting a teenage girl.
And they've come back, flown under the radar, and have struck again.
In the wake of a KARE 11 investigation, State Representative Matt Grossell began working to introduce new legislation aimed at closing a legal loophole that allowed Glenn Johnson to admit in court that he molested a 14-year-old girl and still pass a background check to work as a bus driver.
Nothing shows up when they do a background check, and there he is driving a bus now.
How can that happen? KARE 11 obtained this 1997 police report showing Johnson, then 32, rubbed the girl's privates. It came to light when the girl's mother found the distraught teen looking up in a dictionary the word molestation. Records showed Johnson even admitted it to police and entered a guilty plea in court as part of a plea bargain with prosecutors, where he got what Minnesota calls a stay of adjudication. Without officially accepting the guilty plea, an Anoka judge put Glenn Johnson on probation for 2 years. But after that, the charges would be dismissed. No conviction on his record.
This was a very difficult case.
Paul Young with the Anoka County Attorney's Office says the plea deal was better than risking losing the case at trial because of shaky evidence.
We didn't reach the perfect result, but the risk of an acquittal or the need to have to outright dismissal was very real.
The imperfect result? An admitted sex offender with a clean record. Minnesota law only disqualifies bus drivers who have convictions. So a man who admitted to sexually assaulting a young girl was legally allowed to drive children to school.
They admitted they're guilty. They still, that should be a law, that they can't be anywhere near a child.
Both the school district and the bus company told KARE 11 they were unaware of Johnson's history. Not surprising, thanks to another loophole. BCA background checks only show convictions. People who get plea deals like Johnson are not flagged.
And our investigation found there are more of these secret sex offenders than you might think.
Analyzing never-before-reviewed state data, KARE 11 discovered between 2006 and 2016, 210 defendants ages 22 to 85 received stays of adjudication for their sex crimes against children, including cases involving sexual penetration of children under 13.
How's that possible that you can have sex with a minor and not have any record of it anywhere?
Following KARE 11's report about how this woman's 11-year-old granddaughter was repeatedly molested by a 47-year-old babysitter who'd gotten a stay of adjudication after admitting in court to sex with a 13-year-old, Governor Dayton called for change.
And I was shocked to see the report.
Crimes against children, so were the lawmakers who watched. But ultimately, they could not agree on what steps to take, and reform efforts stalled.
I don't like to say it died. It got delayed.
Representative Grossel vowed not to let the issue die and says he's now working on a new bill to introduce next session that would add a measure of transparency and accountability to the secret sex sentences.
Even if it's a stay of adjudication, let's say, that they're going to have to register as a predatory offender.
Last month, Glenn Johnson entered a guilty plea to his latest sex crime and this time will have to register. But his case shines a school bus-sized light on what can happen when sex offenses are kept secret.
And it should not be acceptable that they receive a stay of adjudication which turns into nothing.